Okay, maybe we should start, huh? Good morning from Hawaii. This is Don Viviani. We're going to talk about our petition to control greenhouse gases using the Toxic Substance Control Act. And we're going to talk about the significance that the recent West Virginia versus EPA decision by SCOTUS is going to have on this. First, I'd like to introduce the panelists. We only have an hour, so I really can't do justice to these folks. But first, there's E. Don Elliott on as a panelist. He's been a Yale law professor for about 25 years, and he's been called one of the most influential environmental and policy attorneys in the country. He's been published extensively, but I think most germane to this is during the first Bush administration, Don was the general counsel at EPA. And I just want to say that we're really lucky to have him here today. And more than that, I'm really, really glad that he's on our side. So thanks a lot, Don.
Thank you. It's a pleasure.
Also here is Dan Galpern. He's the founder and general counsel and executive director of the Climate Protection and Restoration Initiative. Dan's been fighting for the public interest and for environmental issues all of his life, but most recently he's been working as the chief legal and environmental advisor to Dr. James Hansen, who's one of my co-petitioners. But I think most importantly in this context, while the petition was originally my idea, if it wasn't for Dan's creative ideas and hard work, we wouldn't be where we are, right on the cusp of possibly moving the needle on climate change. So thanks, Dan, for everything you're doing. I'm Don Viviani. I was at EPA for 35 years. I had a lot of different jobs. Most germane, though, I think, to this particular petition is the fact that I was Director of Climate Policy Assessment Division in the Office of the Administrator at EPA. I also supervised the group that looked at TSCA policy, and I was chairman of the International Great Lakes Water Quality Board's Toxic Substances Committee. So I know a little bit about this topic. And my doctorate, I have a chemistry doctorate. Now, I guess the next thing is Dan's going to, the order of business here is Dan is going to give a brief explanation of the petition, and then Don is going to the other Don is going to give an opening statement, and then I'm going to weigh in with a short, brief opening statement, and then we'll get to the questions. Dan?
All right. Thanks, Don. Really appreciate it, and I appreciate Don Elliott for being here as well, and all of you who are signed up for the webinar, and especially, of course, those of you who have endorsed the petition and are sponsoring the campaign to get this over the finish line. It's been a long time coming, getting this petition in order and filed. So I'm going to share my screen for a second. Am I successfully sharing?
Yes.
All right. So we filed the petition, and here are the petitioners, individual petitioners. They include Don Viviani, our host today, Dr. James Hansen, the well-known climate scientist, John Birks, the well-known atmospheric chemist, professor emeritus at the University of Colorado, Rick Heady, probably the preeminent climate accountability analyst, Lisa Van Susteren, the physician and writer, and two organizational petitioners, Climate Science Awareness and Solutions and CPR Initiative. And essentially, this petition attempts to get after the two main causes of dangerous climate change. One is the continuing emissions. We need to, according to the relevant scientists, as rapidly as possible, and certainly, hopefully, and largely by the middle of this century, we need to have phased out additional fossil fuel and other sources of greenhouse gas, man-made greenhouse gas emissions. Secondly, however, because we've so overshot the safe level of atmospheric CO2 and some of the other Kyoto 6 greenhouse gases, but especially in light of the long residency time of CO2 in the atmosphere, millennia, we need to remove a substantial amount of the overburden of the excess greenhouse gases that remain in the atmosphere, the so-called legacy emissions. And this petition attempts to get at both. Now, I should also say, in terms of timing, if I can quickly say that, we filed on June 16. So by law, under the Toxic Substances Control Act, that kicks off a 90-day period within which EPA needs to make a threshold determination. And that's what the petition formally is requesting, actually, this threshold determination. Whether or not greenhouse gases, these chemicals, present a risk of injury, an unreasonable risk of injury to health or the environment. That's the operative language. And in my view, it's crystal clear language. Or not. If they decide that these substances do present an unreasonable risk of injury to health or the environment, well, then they must commence a rulemaking. And that rulemaking likely would take a number of months. And they are to select from among 7 different, and I won't go over them all, but 7 different types of requirements that are specified by Congress in Section 6 of the Toxic Substances Control Act. And I'll mention just 2 of them right now. Again, in the event that the administrator makes this threshold determination, that the manufacturer, which includes the production and also importation, but the manufacture, processing, distribution, and Congress, use, or disposal, I'm looking at the text of the law in front of me here, or any combination of those activities presents an unreasonable risk of injury to health or the environment, well, then the agency must apply one or more of the following requirements. And the 2 that I want to mention is, first, a requirement prohibiting or otherwise restricting the manufacturing, processing, distribution, and commerce and use of the substance. So prohibiting or restricting. And 2, a requirement prohibiting or otherwise regulating any manner or method of disposal of such substance or mixture. Well, how do we dispose predominantly? How do we predominantly dispose of greenhouse gas pollution? And to date, it's just been released into the atmosphere. So under the petition, we're demanding the threshold determination, and then upon that favorable determination, a rulemaking leading to an attempt by the agency to fashion requirements to the point necessary so that the chemical substance, that is the greenhouse gases, no longer present such risk, no longer present an unreasonable risk of injury to health or the environment. So the language, in my view, is expansive. It's capacious. It's a significant conferral of authority to the agency. And I just want to say here at the outset, or at the close of my opening, that it's not just us who think that. And so let me key over to here. This is the 2017 decision by the DC Circuit Court of Appeals. And in that case, just like in West Virginia versus EPA, there was also a challenge to a 2015 EPA rule. That rule, in that rule, the agency attempted to regulate hydrofluorocarbons, HFCs, which are potent greenhouse gases on order of 5,000 times more potent than, on a molecular basis, than CO2 over a 20-year period, nearly 100 times more potent than methane over that same period. And the agency sought to do so under Section 612 of the Clean Air Act, Title 6 of the Clean Air Act, and specifically Section 612. And the court found that the agency did not have sufficient authority to compel companies that had already switched from CFCs to what EPA had at once deemed to be safer and a safer alternative, HFCs, that they couldn't do that under 612. They could do it going forward, but not going back. But the court proceeded to say EPA possesses other statutory authorities that could get after HFCs that are in existing appliances or used as refrigerants, including the Toxic Substances Control Act, to directly regulate non-ozone depleting substances that are causing harm to the environment. And it listed that authority as well as a couple of others. And the court said, our decision today does not in any way cabin those expansive EPA authorities. Now, this is important because, not only because this is a decision by the DC Court of Appeals, perhaps certainly the second most important court in the land, but also in light of who actually wrote the majority decision. It was then Judge Kavanaugh, now Justice of the Supreme Court Kavanaugh. So this, I think, is an important statement. It confirms what is plain on its face if you actually read the statute, that Congress and the Toxic Substances Control Act conferred on the agency substantial authority to restrict, to the point of prohibition, substances that present an unreasonable risk of injury to health or the environment. And that is the fundamental legal predicate, legal basis for the petition. And just to cut to the chase with respect to my own opinion, and Don, of course, will be talking about the case in perhaps more detail, I think that the legal basis for the petition survives the majority's opinion in West Virginia versus EPA. Okay, that's my opening, and I'll stop here and then let Edon Elliott have a few minutes.
Well, thank you very much. I'm going to talk primarily about the implications of the Supreme Court's recent decision in West Virginia versus EPA invalidating the 2015 Clean Power Plan. And I'll try not to get into the legal technicalities that we law professors love so much. Let me just say that I think not only as Dan Galperin said, not only does the petition under Tosca survive the Supreme Court's decision in West Virginia versus EPA, I think the decision in West Virginia versus EPA substantially strengthens the rationale for using the Toxic Substances Control Act to address greenhouse gases. In general, what the Supreme Court said in West Virginia versus EPA is even if something is within the literal language of a statute, and they actually use the term capacious language, just like Dan Galperin did. So they basically said, even if something is within the capacious language of the statute, for a variety of reasons, it may not be within the agency's authority. And that is the so-called major questions doctrine, which has been developing over a number of years, going back to a case called Brown and Williamson, which held that the FDA did not have authority to regulate cigarettes, even though cigarettes are addictive drugs and drug delivery devices. So it was literally within the wording of the statute. What the Supreme Court said, no, that's really not what Congress intended. And they cited a number of instances in which the in which the Congress had been asked to enact specific legislation and had declined to do so. It's interesting to note, I think, that immediately thereafter, Congress essentially amended the FDA law to give FDA that authority. So in some sense, they overruled the initial decision under the so-called major questions doctrine. My view is pretty much every decision the EPA makes would trigger the major questions doctrine that, as the court has defined it. That's because they haven't defined it very well. But there was an excellent amicus brief by Ricky Revesz, the former dean at NYU, outlining all of the other instances in which EPA decisions would trigger the so-called major questions doctrine. I have written in the American Spectator that I don't think the court should have reached the merits of the decision, but also that I do think the major questions decision or the major questions doctrine is really an abuse of authority by the Supreme Court. It allows judges to essentially ignore the literal language of the statute and basically say whether or not, as a matter of common sense or their sense of things, that that something is outside the statute. I've also previously written that I think it's extremely unfortunate that the courts ruled in 2007 that EPA has authority to regulate greenhouse gases as pollutants, but subsequently, under the Clean Air Act, but subsequently have been very restrictive in holding repeatedly that most of the techniques, including cap and trade programs, which are the techniques that would be most likely to be used, are beyond the agency's statutory authority. So I think they've got to have it one way or the other. As somebody who was active on this issue and actually first suggested that EPA could regulate greenhouse gases under the Clean Air Act in 2008 and have written several articles subsequently, other ways it could regulate greenhouse gases, including imposing a user fee under the Independent Offices Appropriation Act, which maybe we'll talk about. I think it's extremely unfortunate if Congress had simply said in 2007, EPA doesn't have authority to regulate greenhouse gases, I have no doubt that Congress would have immediately given EPA that authority. So we've had a 15-year shell game, really, basically, where EPA has tried and failed to regulate it successfully under the Clean Air Act. I think there's a very, very good case, a very strong case for EPA having authority to regulate greenhouse gases under the Toxic Substance Control Act, in addition to the case that Dan Galperin has cited. And one of the primary reasons for that is that there is specific language in Section 9 of the Toxic Substance Control Act, which is codified at 15 U.S.C. Section 2608, that specifically talks about the relationship between the Toxic Substance Control Act and other statutes. I think the biggest problem with getting EPA to regulate under TSCA is it seems like it's an air problem. And I am concerned that judges who don't understand how the Toxic Substance Control Act works may simply say, well, it's an air problem, so you got to regulate it under the Clean Air Act. That's not what Section 9 says. Section 9 of TSCA specifically contemplates taking action under statutes either administered by the administrator of EPA or other authorities that might also be devised or that might also be used to address a problem. And Section 9B specifically talks about other statutes administered by the administrator. And it says, if the administrator determines that a risk to health or the environment associated with a chemical substance or mixture could be eliminated or reduced to a sufficient extent, then he should act under that law. Well, the sufficient extent, I think, because of the inability to require the scavenging or collecting of existing greenhouse gases that have already been disposed into the environment under the Clean Air Act, I think that in and of itself is sufficient to argue that regulation under the Clean Air Act would not be sufficient. But Section 9 goes on and says, if you can regulate it to a sufficient extent under another statute, you should do that, unless the administrator determines in the administrator's discretion that it is in the public interest to protect against such risk by actions taken under this chapter. So we have very clear textual evidence that Congress contemplated using the Toxic Substance Control Act, even though other statutes, such as the Clean Air Act, might also be used to regulate, and gives very, very broad discretion to the administrator to make a determination that it's in the public interest to use the authority under TSCA. I think the evidence that we need to not simply stop releasing greenhouse gases, but we need to do something about the greenhouse gases that are already in the atmosphere makes really a compelling case that the Toxic Substance Control Act is the best way to go. And I'll leave it there and be glad to answer any questions about West Virginia versus EPA or the Clean Power Plan or the Clean Air Act in the questions. Don, do you want people to put their questions into the chat or raise their hands, or how do you want to do that?
I think right now people are putting it into the chat, and I thought what I would do was I would just read the questions, or if people want to actually read them themselves, they should just indicate that in the chat. Thank you, Don. That was really great, and Dan, that was also excellent. I just wanted to to give a chemist's perspective, and there's something that I don't want to get lost in all this. Some of the argument in West Virginia concerned the idea that EPA was reinventing 111 as a climate authority, and also that the Clean Air Act really is in the business of controlling air pollution, not dictating how the U.S. should generate energy. And it was also pointed out that EPA is not expert in the generation of energy, so it really wasn't their business. On the other hand, TSCA is a chemical safety authority. It is in the business of controlling risks from chemical releases and exposures, and it is expert in emission tracking, fate and transport, and risk assessment. We're not reinventing TSCA as a climate authority. We're controlling unreasonable risks from chemical release. Some are climate, but others, like ocean acidification and mortality and morbidity from combustion products, aren't climate issues. So this is TSCA doing what it's supposed to do, controlling unreasonable risks from chemical manufacture, process, use, and disposal. Congress must have included the entire life cycle of a chemical in there for a reason. So the authority is clearly there under TSCA. I guess we should go to the questions now. So far, I only see one question.
Yeah, but Don, actually, could I just add on to that for a second? Because that was an important point that you made. And I want to go back to the ozone depletion issue partly, and CFCs, because, you know, the effort in the United States to ban CFCs began in 1978 under the Toxic Substance Control Act. And in its rule, both in the draft and its final, EPA provided two reasons. Number one, because the continued release of CFCs was damaging the ozone layer, which protects human health and the environment. But also, specifically, because CFCs are a powerful greenhouse gas, and banning CFCs was necessary to protect against global warming. And so I think it's important to know here that specific administrative history by this agency of restricting a well-mixed greenhouse gas under TSCA because of its climate change, its global warming impact. Just wanted to add that on.
That is great. Dan, thank you very much for
and we review that history in the petition itself, so it's available for people who want to read it.
So the first question we got was from Rob Bricks, and he asked Dan to talk a little bit about CPR, who we are and what we are and what the mission is.
It's CPR initiative. It's the Climate Protection and Restoration Initiative, and the website is pretty easy. It's cprclimate.org, and there you can find the mission statement and the various efforts in which we have been engaged. But this is our first enormous lift. But I founded, along with colleagues, and Don Viviani, I'm not sure you said this, Don, but Don is the president of our board of directors. I founded this after working, as Don said, for a number of years on the climate issue, including serving as the lawyer and policy advisor for the climate scientist Jim Hansen, and I continue to do that, of course. And Jim here is one of the co-petitioners, and he serves on the board of advisors of this group. But the aim of the organization is to figure out the most efficient, viable ways to tackle the climate crisis, including looking first at our own nation, the United States, and how can we move it from being, I don't know what you would say, at best a laggard on this issue with respect to getting after the problem. And also because, of course, we have released more greenhouse gases that remain resident in the atmosphere, and so we're the largest contributor to the problem. Under the assumption that if the United States then becomes a leader in this area, then other nations may well join in. And I should also say, getting down into the weeds a little bit, but the Toxic Substances Control Act, if action is taken under it, does allow the Treasury Department through the customs to impose tariffs on imported goods with high embedded carbon, where the exporting country, the country of origin, does not have an equivalent program to phase out greenhouse gases. So in this way, action in the United States could become somewhat global, especially because the United States is the biggest consumer of products worldwide. In any event, the idea of CPR initiative is to figure out most efficient and effective ways to move the needle and get the United States to be a leader in this area. And of course, we also are working at the international level somewhat as well. And I should say, with respect to this petition, we are seeking, because the decision has not only scientific, implications and policy implications, but political ones as well. We're attempting to show broad support, and so on our website, which I showed before, we are seeking people to endorse the petition and sponsor the petition. And starting Monday, we will also have a portal to enable people to most conveniently provide public comment on the record to the docket of EPA. So we're looking at this also as a tool to help people move from climate despair to action, to do something significant at a propitious time, an important moment. Because after all, this is an administration headed by a president who, both as a candidate and as president, has said that we are here confronting an existential threat. Well, there are viable alternatives. And as you've pointed out before, Don Viviani, where you have an existential threat that's really optional, well then, to us at least, that seems to be the definition of an unreasonable. Anyhow, that was a long answer to a simple question.
Okay, Dan, thank you. Prasad, who's an atmospheric chemist from Duke University, asked a couple of questions. He's next on the list. He says, as you know, a few years ago, EPA denied a very similar petition by Don Viviani to regulate greenhouse gases under TSCA. What is different now with regards to this petition? And not to go into a lot of detail, I guess the two major differences is that that TSCA was reauthorized in 2016, so that the agency only has to look at risk in making the unreasonable risk decision. It doesn't have to look at costs and benefits, although it is compelled to be efficient in its response. And the other thing is that we've added other chemicals and other effects to to that petition, which only looked at ocean acidification. And the second part of his question was whether the CFC history versus TSCA applies to CO2, given that CFC is a chemical specifically manufactured for use as a chemical, while CO2 is largely a byproduct. And thanks, Prasad. We've already discussed this, so thanks for the softball question. CO2 is not a byproduct. CO2, fossil fuels are burned to produce CO2 because in order to harvest the energy, you have to create the CO2, and the energy is harvested from the formation of the carbon-oxygen double bonds. So even though the product only exists for an instant, it is the intended product. And also, obviously, in the internal combustion engine, it's the CO2 that's produced that's driving the engine, that's driving the piston. So there again, it is in fact the product. The next question is from Steve Wheel, and I know Don Elliott will appreciate this one because he's opined on this before. With the West Virginia decision, it appears that the Supreme Court has said that they will determine what Congress meant EPA to do regardless of what the law actually says. Is there a fear that they will make a similar decision if EPA uses TSCA, which would seem to clearly give EPA authority? And thanks, Steve. Steve, by the way, used to run the TSCA branch at EPA. Don, did you want to take that?
Yeah, and before that, I wanted to quickly answer the question of whether or not TSCA only applies to chemicals that don't naturally occur. And the answer to that, which is also in the chat, the answer to that is no. TSCA can apply to naturally occurring substances, and there are lots of examples where that's been done. And I agree with Don Viviani that one of the major differences between now and the previous petition is the 2016 amendments to TSCA, which I think make things a lot stronger. But also the developments in the meantime, including the West Virginia versus EPA case. Steve Weil's question is a tough one. I do think that there is a majority on the Supreme Court that is concerned about overly broad delegations of authority by the Congress, and Congress avoiding making the difficult decisions. And that comes out pretty clearly in Justice Gorsuch's concurring opinion. I think it would have been relatively easy for the Supreme Court to have held that the Clean Power Plan was outside EPA's authority without invoking the major questions doctrine. We could get into the reasons, but among other things, the kind of authority to shift state systems from coal and fossil fuels to renewables is not authority that Congress has given to FERC, the Federal Energy Regulatory Commission. So it seems quite unlikely that it was given to EPA through the back door. Supreme Court doesn't really note that, although that was a mainstay of the Trump administration's arguments in the court in the court below. I think the 6 conservative justices of the Supreme Court are looking to restrict the administrative state, and I think this really was a decision not so much about climate as restricting the creativity of administrative agencies to use interpretations of statutes more generally. And so, yes, I do think there's a risk that if EPA acts under the Toxic Substance Control Act, that courts might try to use the major questions doctrine to say that it doesn't have authority to act there either. Here, I think the language indicating the authority to act is really much clearer than it was under the section 111D. If I were looking for a section of the Clean Air Act in which to restrict greenhouse gases, I would not have looked at section 111D. I thought it was very clever interpretation and made sense to try to do a cap and trade program. But I think it was a rather tortured argument. I think the case is much stronger to be able to use TSCA than it was Section 111D because of the specific language of the statute about disposal and about regulating when regulation is insufficient under other statutes. But is there a continuing risk that the court will strike down action under TSCA 2? I'd have to be honest to say, yeah, there's a risk. I just think it's an awful lot lower. I think there's a much better chance. And if the Supreme Court ultimately says that it can't be dealt with under either the Clean Air Act or Toxic Substance Control Act, then I think Congress will have to respond. I think the big issue under West Virginia versus EPA is whether or not the court can essentially force Congress to deal with difficult policy decisions, which it doesn't want to do for political reasons. I'm really skeptical of that. I think that the majority of the Supreme Court, many of whom are graduates of the Yale Law School since I've been teaching there, including Clarence Thomas, who was my classmate at Yale, and Alito, who was a year behind me. I think that they just have a really rather unrealistic sense of the Constitution and the notion that Congress should make all of the big policy decisions, and I just don't think that's realistic.
Thank you, Don. I actually have a question that I wanted to get in there. I was wondering if EPA is limited to command and control best technology or emission limits under TSCA, or can they use market solutions? Because they've never used market solutions in TSCA before. And I know that the Supreme Court made a big deal out of, bringing in a brand new idea into an old law. So did Dan or Don, do you have a sense of whether or not they can use market-based solutions?
Well, it depends on what you mean by market-based solutions.
For example, a carbon fee.
Yeah, I think the case for imposing a user fee on carbon is stronger under the Independent Offices Appropriations Act, which we've talked about and is also part of another petition by CPI. I do think a cap and trade program is arguably possible under TSCA. The Supreme Court has been willing to uphold the existence of cap and trade programs in the interstate air pollution context without specific statutory authority. However, I do think it's fair to note, and Rob Brenner, who's on, will remember this. We tried in 1990 to get standby authority under the Clean Air Act to impose trading programs for pollutants other than SO2. The acid rain trading program was limited to SO2. And we actually had in the House bill authority that gave EPA the authority to use cap and trade programs with regard to other pollutants. And that was taken out in the Senate. And one of the bothersome things about the major questions doctrine is the court tends to look at proposals in Congress that were not enacted and say, well, if Congress didn't enact a specific proposal, then that's evidence that you can't do it under existing statutory authority. So I think there's a good case for allowing trading and a cap and trade program under TSCA, but it's not ironclad. I think one of the reasons that the authority to impose a carbon fee is stronger is that as far back as 1985, EPA in a number of official documents said our authority to impose user fees is under the Independent Offices Appropriation Act, and other agencies impose user fees to the tune of over $100 billion a year. So I do think there's a case for imposing user fees for using the atmosphere as a disposal method. But in answer to your question, I do think it's a close case, Don, whether or not a trading program would be permissible under TSCA. I think it should be. If I were general counsel, I'd tell them that they have a good defensible argument. But I do think the courts have indicated more skepticism about allowing agencies to be innovative than I think is appropriate.
Yeah, if I could, I agree with everything that Don Elliott said. I just wanted to point out that we do specifically call out as another authority of EPA its ability to proceed to impose a rising carbon fee under the Independent Offices Appropriations Act. And so, pursuant to Section 9, which Don Elliott talked about before, we certainly think that it could come in here. On the other hand, it could be a parallel rulemaking. There are, regulations under the Independent Office Appropriations Act, I think, that should be pursued, and so a full rulemaking under TSCA here, pursuant to our petition, could include or could exclude a rulemaking under the Independent Offices Appropriations Act. But either way, I think that it is a significant authority that EPA could utilize to at least to impose a fair share burden on continuing emissions if they are going to be permitted at all, at least even in a phase-in period under the rule that would be devised pursuant to our petition.
Thanks, Dan. Thanks, Don. Kathy Orlando asked that we mention the 1978 restriction of CFCs under TSCA, where the agency banned the use of CFCs, and because of their ozone depleting action, but they also mentioned as an ancillary reason for banning them was the fact that they had great global warming potential, and that actually gets to another question that I had, was that under the utility air decision, that focused on EPA's on the fact that EPA would have to permit tens of thousands of stationary sources of CO2 because the emissions are everywhere, and that was one of the reasons they denied that. Is that a problem for TSCA? And I also wanted to point out that in that same decision, that 1978 EPA restriction, they did carve out some special uses of TSCA of CFCs that the agency did not have to regulate. So does the fact that CO2 is just so pervasive everywhere going to be a problem for EPA in terms of, or can they use a de minimis argument?
Well, there are a couple of questions there, Dan. One of the questions that Kathy asked is whether or not the 1978 EPA restriction of CFCs was agreed upon by the Supreme Court. I don't believe that actually went to the Supreme Court. I could be wrong about that, but I don't think it was. But under this major questions doctrine, one of the factors that the court looks at is whether or not the agency has previously used its authority in this way. And I think the fact that going back to 1978, which is many years ago and shortly after TSCA was enacted, the fact that they used their authority to restrict CFCs, a very strong argument under the major questions doctrine. I think the major questions doctrine is misguided, but if you accept the major questions doctrine, the fact that EPA was regulating CFCs back in 1978 is a very strong argument that this is not something that has just been, dreamed up recently because they can't get authority through the Congress, which is what the court really seems to be concerned about in the major questions doctrine. So that's the first question. The second one, Don, is Don's very good question about a large number of individual sources. And this is an issue that I confronted back at when I was general counsel of EPA. There are plenty of ways to do to deal with hundreds and thousands of small sources. They're what are called general permits, and we do them particularly with regard to permitting small wetlands under Section 404 of the Clean Water Act. So you can have a general permit that applies to all dry cleaners in the United States or whatever. You don't have to permit them one by one just because it's called a permit. It's a well-recognized device to have what are called general permits. So I don't have much difficulty with imagining that EPA could regulate broadly under TSCA, despite the fact that there are a large number of sources. And of course, that's going to be a problem however you try to regulate it. And the way you deal with it is with generic regulation and general permits.
Well, so I agree with that, but I think that the law is clear, TSCA is clear, that the agency can restrict at any point in the life cycle that makes most sense. And the truth is that the majority of greenhouse gas emissions in the United States and elsewhere is produced by the consumption of fossil fuels, oil, gas, and coal. And the statutes express that that the agency can prohibit or restrict even at the point of manufacturing, and manufacturing is expressly defined in Section 2 of the Act to include production and importation. And so you could be going after the major sources under TSCA, and only that if that was deemed sufficient by the agency, after reasonably, to be the full extent necessary to control the unreasonable risk. And so I think the agency is able to tailor its rule or rules pursuant to this petition under TSCA. The agency can phase in, and the statute expressly allows for a phase-in period. The statute gives the agency considerable flexibility in the event of a emergency, including for national security reasons. And so all of these factors are available, all of these options are available to the agency to tailor its rule and to fashion a rule in such a way that it's most efficient and is reasonable. And we point this out in the petition as well.
Thank you, Dan. Rick Heady, one of the co-petitioners, asked the question: does TSCA, in your opinion, the intent of Congress, make any relevant distinctions between artificial chemicals such as CFCs and naturally occurring chemicals such as carbon dioxide or elements such as mercury or radon? And I think I would point out that TSCA has actually regulated both. It's obviously it's regulated natural chemicals such as formaldehyde, but that are produced in an unnatural way. That is, that they're the result of degradation of urea formaldehyde resins in particle board. But they've also regulated unnaturally occurring chemicals, which is dioxin. Nobody makes dioxins on purpose, or PCBs. So we can do either. And then we have a question from Mary Wood. Given that knowledge of the climate crisis has existed for a year, I'm sorry, it keeps moving because people keep adding more ones. Given that the knowledge of the climate crisis existed for a year, the TSCA approach is the TSCA approach potentially more certain? Why wasn't it pursued first? Does it have a downside versus the approach that was just defeated? And I'll let the Don and Dan answer that, but I just want to say it has an upside, is that it hasn't been defeated yet. So Dan, Don.
I'd like to address that one. I don't think it has a downside as opposed to the approach that was that it tried and failed. However, in light of the provisions of Section 9 of TSCA that I referred to earlier, if I had been at EPA at the time, I would have probably advised the administrator that you've got to try to do this under the Clean Air Act first, because the statute specifically says that TSCA, where a chemical or a substance can be regulated under more than one statute that is administered by EPA, EPA has to first determine that it can't be sufficiently regulated under the other statute. And the word climate is actually mentioned in the 1970 Clean Air Act, but under a section that applies to national ambient air quality standards and welfare effects, not the section that EPA tried to use. So I think it was appropriate to try to do it under the Air Act. But I think once it's become clear that as the courts have construed the Air Act, it's not a very effective tool. In fact, in West Virginia versus EPA, they specifically concede that as the Trump administration, that the kind of action that they can take under Section 111D that the court says is permissible will only have really minor effects. So remember that Section 9 says if another statute doesn't regulate it sufficiently, then you can deal with it under TSCA. But TSCA is specifically designed not only to regulate chemicals, and chemical substances and mixtures, but to do that on a fallback basis where there's another statute. So, if you had something that was being discharged into the water, you'd have to try to deal with it first under the Water Act, unless the agency can make a specific finding as to why it's in the public interest to regulate under TSCA instead. So it is specifically supposed to be a fallback statute.
I actually, Don, could I add to that just a little bit? Again, I agree, but I want to say that I think that continuing attempts to regulate greenhouse gas emissions under other authorities make perfect sense and would mesh well with a phased-in prohibition under TSCA. So I think that there should continue to be, attempts to ratchet down greenhouse gas pollution under Section 202 from tailpipes, autos and light trucks, use of the National Ambient Air Quality Standard provisions of the Clean Air Act, to me also seem to make some sense. And so, I think that these authorities could work well in conjunction with TSCA.
Yeah, and I don't disagree with that. And if I wasn't clear about that, I wasn't saying that we shouldn't also try to attack the problem on the Clean Air Act.
Right.
I had understood the question to be, why didn't we regulate greenhouse gases first under TSCA?
Right.
And I think part of it is just because people felt like it was an air pollutant, but you also had this a decision by the Supreme Court in 2007. First, you had a petition by Massachusetts to regulate it under the Clean Air Act. But then the Supreme Court held that it was an air pollutant under the Clean Air Act. So I think that made people feel like this should naturally be dealt with under the Clean Air Act. As the courts have subsequently construed other provisions of the Clean Air Act, they've made it pretty difficult. And I think that it's now time to turn to the possibility of using TSCA, which, as Don Viviani and you point out, Dan, gives EPA very broad authority, including over disposal. If I could pick up on one of the interesting questions, Don, I don't want to.
Please, yeah, no, please.
Yeah, somebody asked a question of, wasn't it the case that one of the additional grounds for denying the previous petition was that the CO2 was mixed with other chemicals, and therefore it wasn't possible to identify particular CO2 with the particular, or connect it with the CO2 that any one entity did for repurchase. I don't think that's a very strong argument at all for not doing it. To the extent that we can estimate what the amount of releases have been, there's no requirement under TSCA that you have to show that each individual molecule of CO2 came from this individual source in order to be able to require cleanup. And in fact, we don't do that, or we do cleanup, say at Superfund sites or whatever. We try to estimate as best we can how much came from this source and how much came from that source, and impose proportional requirements for cleanup. But there's no requirement that that you have to be able to identify. And in fact, if you think about it, that would make it basically impossible, not only under TSCA, but under any cleanup statute, because it's really very rare that you can trace, for example, the PCBs that came from one facility as opposed to the PCBs that came from another facility. Sometimes you can try to do chemical footprinting, and I've been involved in a number of cases where where you try to do that, but it's an inexact science. And when you have a substance like CO2, it is true that all the molecules are alike, but that doesn't mean that you can't require the cleanup.
Yeah, and to add to that, the agency traditionally looks at pollutants as fungible, levels as fungible. For example, if you have a limit in a body of water of a certain amount of a particular chemical, and you're supposed to clean it up to a different level, it doesn't matter if you're cleaning up the stuff that was discharged from the plant or the stuff that was naturally occurring, as long as you get down to the limit. So it's more of a question of reaching a limit. It's not.
Yeah, and just to add to that, somebody has commented, Rick Heeds, I guess, that the Carbon Majors database identifies the CO2 emissions of the largest 100 companies that produce oil, natural gas, and coal. There is no requirement under TSCA that you regulate all sources of CO2 at the same time. You can take a step-by-step approach, and as Dan Galpern referred to in terms of phase-in, it would be quite reasonable for EPA to start with requirements on the largest emitters and those for which the database is best, and impose requirements on them first, and then move to the smaller sources. That is a very, very common regulatory technique to regulate the sources that it's easiest to regulate first, and then come back and deal with the smaller sources later.
It's actually 9 o'clock, so I don't know. Are we going to end now, or are we going to continue on for a while? I'm available.
How are we doing in terms of the questions that are coming in?
Well, we've got a few more questions. I actually had one. Can the court claim that Section 6 is an ancillary?
I think we can go for another 10 minutes. I'm fine with that. Don Elliott, are you fine?
Sure.
And if either of you folks, Don or Dan, see a question you want to particularly jump to, you please do that. I wanted to ask whether or not the court could claim that Section 6 is an ancillary provision of TSCA, little used, which is true, and not meant for a massive program. This is an argument they used in the Clean Air Act versus in the West Virginia decision.
Go ahead, Dan. You deal with that first, but I've got a strong.
Well, look, I think we're dealing with a vastly strengthened statute. I think one of the major reasons why Section 6 wasn't utilized very much before was because EPA was thwarted at the threshold question determination, because they would, that is to say, whether a particular substance or mixture presents an unreasonable risk of injury to a health of the environment. Because rather than sticking on the precise question of risk, they were moving ahead to what would be the probable cost of a regulation to eliminate or restrict that substance. And then, in light of that, they would say, well, it's probably unreasonable because it would be hard to bear that cost and that sort of thing. And so they didn't make many of those initial, favorable determinations. But Congress spoke clearly, and by the way, it was overwhelming and bipartisan. And they said, look, we intended for there actually to be action to clean up these chemicals, and so one of the major amendments was to Section 6, where they said that determination needs to be based on risk alone, and not on costs or other non-risk factors.
So I lived through a number of those early wars with regard to Section 6 of TSCA. In 1989, when I was at EPA, we attempted an industry-wide regulation of asbestos, an asbestos ban rule. That was a very broad decision. It was set aside in a very, I think, inappropriate case called the corrosion-proof fittings case that by happenstance happened to be written by my law school roommate, Jerry Smith, on the Fifth Circuit. So Jerry and I see each other from time to time, but we don't talk about that case. It actually really wasn't Jerry's fault. What happened under the Toxic Substance Control Act was it was bottled up in committee by the chemical industry for many years. And when the Keystone disaster happened on the James River, the politics changed. It was no longer possible to keep it bottled up. But the industry went along with it in response to a number of what are typically called in Washington killer amendments that made it very difficult to use TSCA. And one of them was a unique provision that said that EPA always had to regulate in the least onerous way possible. And when you think about it, it's almost impossible to come out with a complete list of all the ways you might regulate and figure out which one is the least onerous. And that was one of the grounds in the statutory language that Jerry Smith's opinion in corrosion-proof fittings relied on. That was specifically taken out in 2016, and they specifically disapproved the corrosion-proof fittings case under Section 6 in the legislative history and in the Congress. And in fact, I testified in both houses of Congress that corrosion-proof fittings was a public health and legal disaster. And Congress ultimately fixed it in 2016. But we have a very good record here because EPA attempted to use Section 6 in very broad ways. And Congress specifically, although it was set aside on what I would call a technicality in the court, EPA, the Congress specifically validated in the 2016 amendments and strengthened Section 6 and made it clear that no, that's exactly the kind of thing that EPA should use Section 6 for. So I think from a major questions doctrine standpoint, although I think that the doctrine is an ill-advised one for the Supreme Court to be inventing, but in terms of the criteria, I think we would stand in excellent shape under using Section 6 of TSCA because there is a history here. There's a history of using that section of the statute in ways that indicate this is not sort of a latter-day invention. It's been used with greenhouse gases. It's been used to try to regulate a substance throughout the economy as a whole. So I think it's got a very, very strong case under the major questions doctrine. And the question I see is from John Turner: how would this square with the petition by the Center for Biological Diversity to regulate greenhouse gases as a criteria air pollutant under the Clean Air Act? You know, I'm all in favor of that. I advocated that publicly in a speech in 2008. I guess it's not telling tales out of school, but the team that was trying to decide what section of the Clean Air Act to use got in touch with me and we talked about it. The main reason they didn't go down the National Ambient Air Quality Standards route is they didn't think they had good enough data to be able to set a standard. One of the problems with national ambient air quality standards is they've all, the 6 that we've set have all been based on concentrations in the atmosphere. And that doesn't really work with regard to greenhouse gases. But it doesn't work with regard to a number of other pollutants as well, like the oxides of nitrogen, which is why we have such difficult interstate air quality problems. The air in Connecticut already violates the National Ambient Air Quality Standard for ozone when it comes in from the western border. So concentration standards are not required by the National Ambient Air Quality Standards. It simply says a standard, and you could very well do a rollback standard. Plus, if you don't have good data in the meantime, EPA has started doing modeling, where you essentially do modeling retroactively to try to estimate what the various contributions, if you don't have actual records. The McCain-Lieberman bill was passed a number of years ago to try to require a registry to try to get good data on amounts of releases. So I'm all in favor of setting a national ambient air quality standard. The reason that they didn't do that in 2015 is that the Obama administration wanted to take credit for tough action on CO2, but they did it in kind of the final year or two of Obama's term, but it actually required that somebody else, the states, would have to do something 3 years later. So, you know, they got credit for taking tough action on climate without actually having to do something, but rather something that would require the states to do something 3 years later. I'm all in favor of a national ambient air quality standard, always have been on record for it for at least 15 years. And I agree with what Dan Galpin said. I think that the two could be used very productively together. I think the mistake that they made in the Clean Power Plan, and it was written by 2 of my former students, they were central designers to it. And so I've always been a little bit quiet. I thought it made a lot of sense from a policy perspective, but it was basically the Obama administration's idea that the easy way to deal with climate was to switch everything to solar and wind. And well, that's part of the solution. I think as we have come to understand the problem in more depth, that's not going to be enough. So it maybe made sense as a first step if you could have done it. But I think a national ambient air quality standard and giving authority to the states to deal with it makes a great deal of sense. And I also think, going to Don Viviani's point, if you did it that way, the case law is more favorable to interstate trading systems. So, you know, I'm in favor of doing both. But I do think what's brilliant about the TSCA petition is it gives you an ability to deal with the greenhouse gases that are already in the atmosphere. And I think that has to be a part of the solution.
Let me just add as a footnote, because I know we're about to close here, that, again, I agree with everything you said, Don. The Center for Biological Diversity petition, I think, was never decided during the Obama administration, and then it was finally rejected at the tail end of the Trump administration. But among the initial acts of the Biden administration was to withdraw that rejection. The administration has not decided on it yet, but it's still a live petition, and we note that in our petition under TSCA, and say, as you indicated, Don, that we think that is an authority that could work in tandem with significant action under the Toxic Substances Control Act. So I just wanted to add one more point, if I could, Don Viviani, before we close, and that is to say that you know, there is now, I think, 68 more days until EPA is supposed to act pursuant to its 90-day deadlines from when we filed. And I think that the agency does look at the number of comments, but also significant comments. And in the portal that we are establishing that will be available on Monday, there's the opportunity for you to tailor your message as much as you wish. But if you do intend to submit very extensive comments along with attached documents, then that should be done directly through the EPA's own portal, and we provide all that information on the webpage that will be coming out as well on Monday. And the other thing I wanted to say is I really appreciate your sharing with us, Don Elliott and Don Viviani, your wisdom from inside EPA and outside. And we look forward to working with you both as we proceed. We need to try to get this across the finish line. We need a significant decarbonization program in the United States, and I think that our petition pursuant to the Toxic Substances Control Act can provide that essential legal foundation that perhaps should be able to stand the test of time or even the Supreme Court. So thank you very much for coming today, and thank you to everybody who signed up and is participating. They're great questions. We couldn't get to them all, but this may be one of several conversations that we have over the next 2 months. And if I can be so bold, Don Elliott, would you be interested in coming back and having some additional conversations if it seems warranted?
Of course, I always enjoy conversations with the two of you.
All right.
Two of my favorite people.
All right, Dons, both, thank you very much.
Goodbye. Thank you.